Life is a journey that we all taken. Every step is guided by its own rules and law. So come, come, come to download. Come, come, come to download. And family law, employment law and corporate law, commission of phones and all the other laws, professional and friendly services we give you all. For all your immigration law, family law, employment law, business and corporate law, welfare benefits, charity law, will, commission of oaths litigation, come to Tanlo Solicitors or simply visit our website on www.tanlo.co.uk or simply call us on 024 776 32323. Tanlo Solicitors, professional and friendly service.
Hello everyone, my name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors, and today I just want to touch briefly on the issue of someone making a recording of a private conversation with a third party. People often ask me that, can I make a recording on the phone of my conversation with a third party? It could be someone whom you know at a private level, or it could be someone, or maybe you are going for an employment tribunal, or you are going to see your GP or someone else and you just want to make a recording of that conversation. If it's a private conversation between two private individuals, yes, you can make a recording of your conversation with that person. You do not need the consent of the other party to make the recording. However, the problem comes in when you want to then share that information with a third party or with someone else. If you do share that information with the information that you discussed in the conversation with a third party, you may be breaching the private rights or the human rights of the person with whom you made the conversation with. Most likely, they believed that it is just between the two of you. It's a private conversation which was going to be held in confidence, and now you are broadcasting it to a third party. So if you broadcast it, that person may have the right to sue you in a court of law, in a civil court of law. It is not a criminal offense to make this recording, but you might be sued in a civil court of law for damages. And normally the defense that might be available to you, if you do go that route, might be that you are now releasing that conversation due to public interest, but you have to prove that there is a public interest element to the reason why you are now releasing that information to the public. So many times people do record their private conversations and then they disclose them or release them on social media, and then they start circulating, maybe damaging someone's reputation or confidence and things like that. So you need to be very careful when you release the information on into the public forum, even social media, because the person involved in that conversation may and has got a right to sue you in a court of law. And also, if the conversation is relating to or is made with a young person or a child, you might be stepping in dangerous ground, and that might also get the police to be involved or the social service to be involved, because the rights of a young child or a young person is always paramount. So where you've made a recording and you want to release it, and you don't have consent, you might approach that person and seek their consent to release the conversation into the public forum, or you might try to seek, in hindsight, that consent if it was not given ahead of the recording of the conversation. If that person gets to know that there's a recording that has been made, and they want to challenge you, they might get an injunction. Some might call it a restraining order, so that you might not be able, or a gagging order, so that you might not be able to release that information or conversation into the public forum. The laws are different when it comes to businesses, because for businesses to record their conversation with a private individual, they need to alert you that they're going to record the conversation and the reason why they're recording it. Mostly they might say it's for training or for quality purposes and things like that. So they have to let you know that they are recording your conversation. Again, like I said, if some people might want to record it for mostly maybe employment matters, or they've gone to their GP, you need to be careful as well in releasing the information, because that they may be able to sue you because you've released the information into the public forum. So that's my brief presentation on the issue of making recordings. You've got a right to make a recording, a private recording, but if you do make the private recording, then if you want to release it into the public forum, it's always good and necessary maybe to make the other person aware that that is what you're going to do. They might ask you not to do it, and they might maybe seek a court injunction for you not to do it. If you have got a defense for your actions, if it's in the public interest for you to continue to release the information, then you might proceed to do so. But the other part might have the right to sue you in a court of law for damages, and it will be up there to the judge who is hearing the case to weigh the evidence and the reasons why that has been done, and maybe they may award damages to the other part who was involved in the conversation. My next presentation will be on the issue of the visitor's visa. I'm getting inquiries. We're now getting into the graduation season, and people want to invite their loved ones from outside the UK to come and attend their graduation. And some might also want to invite their friends to come and tour the UK, as it is nearly summertime. As a proviso, I would want to highlight that some countries are on the red list for COVID-19, and some countries are not on the red list for COVID-19. However, putting COVID-19 on the side, if you want to bring someone for your graduation ceremony, that is quite possible, depending on the circumstances. You will need, firstly, I would say, an invitation letter, which might be issued by the university that you have been attending, and that university will write the invitation letter to say XYZ is qualified, and they're going to invite ABC and DEF to attend the graduation. There is also need to prove that there is accommodation where you'll be able to stay, and that there is sufficient funds for either from yourself or from your sponsor, that you'll be able to stay in the United Kingdom without any recourse to public funds. So you can produce such evidence, and further to that, the Home Office will normally want to know the circumstances of the applicant. In other words, the person who is being invited to the United Kingdom. So they want to know whether you are working, whether you've got assets, you've got a family, any reason that will make you wish or want to go back to your home country before the expiration of your visitor's visa. So it doesn't matter if you've been given a visitor's visa for 6 months or 2 years, 5 years, or 10 years. You just have to stay in the United Kingdom a maximum of 6 months in a period of 12 months. So having a long stay visitor's visa in the United Kingdom does not mean that you have to stay all the 10 years or the 2 years in the United Kingdom. It is also important to submit your application in time, as we know that there is delays that are being caused because of COVID-19 at the moment. And like I indicated, there's the issue of the red list zones for COVID-19. So if you are coming from, or if you are the person invited is coming from a red list country, then they might need to check if they can come, because at the moment it's only people who are resident in the United Kingdom or who UK citizens who are coming from abroad, if they're from a red list country, who can come until maybe that red list is revised or that country is removed from there. So it might be a good thing to check whether or not, um, even if you get the visa, you'll be able to come because of the COVID-19 precautions that the United Kingdom government has put in place. If you are coming to tour, not for a reason of attending a graduation for someone, then you might need to produce your itinerary of the places that you're going to visit, who you're going to visit with, the places that you're going to visit, the funds that we have for the tourism or tourist visit that you are going to do, and you produce such evidence to the Home Office. And with such evidence, then you can be able to make that application successfully to the Home Office. So if anyone has got any questions regarding the visitor's visa on the aspect of coming to a graduation ceremony or for coming to for tourism to the United Kingdom, you can put it in the chat and I'll be able to respond to that. Or if there's any other question that you might have on the topic that I first presented about making a covert recording of your conversation with someone or any topic on immigration, I might be able to answer those questions as well. If you make an application for the visitor's visa to come for the graduation or to come for tourism and it is rejected by the Home Office, you might apply, you might challenge that decision depending on the evidence and the reasons given for the refusal. So there is ways to challenge it. It will not be an appeal, it will be a review that can be done, and the Home Office can review the decision. If they've maintained their decision, then you can apply to the court for a judicial review, and you can then challenge them in a court of law and for judicial review. But all that will depend on the circumstances and the reasons given. Sometimes it might be worth starting the application again rather than to go all the way challenging the decision, which might be expensive, rather than to just submit a new application and you might get a new decision quicker than going to court. But again, like I said, this is dependent on the assessment that has to be done on whether or not it is prudent to either make a new application or to challenge it on review. So it's an assessment that needs to be done under those circumstances. At Tanlaw Solicitors, we are a firm that that does immigration, employment law, civil litigation, and we also draft wills. So for both topics that I've presented today, we will be able to assist you one way or the other. We've got solicitors that handle civil litigation matters. So the issue of a private conversation with someone being recorded and released into the public forum is it will be a civil litigation or a dispute that can be resolved. And we've got solicitors who are able to handle such matters. And we also have solicitors who do immigration, which I've touched on, or employment, which I've touched on, where someone is attending, say, a grievance procedure or a disciplinary hearing, and maybe they have made a recording um, of their disciplinary proceedings or grievance without necessarily the knowledge of the employer or any third party that is involved. Our solicitors should be able to give you requisite and relevant advice under the circumstances. So this is our presentation for this week. My name is Andrew Nyamayaro, Solicitor Tanlo Solicitors. Next week, I hope to make a presentation on the NMC, which is a regulatory body for nurses and midwives, on the disciplinary proceedings in the NMC and so forth. So thank you so much for watching today. I do not see any questions in the chat, so I will end our conversation today, and we will be meeting again next week. Thank you.